My name is Ken Kramer. I'm a sole practitioner, a lawyer practicing in downtown Vancouver with a practice exclusively in the area of estates and trust law. I have a very good understanding, good relationship with the disability community and have so for many years. And one of my major projects outside of the practice of law is around home care in our province. I'm advocating for families looking for support for family members in the community and also assisting families in the world of CLBC. And so when I wear a number of other hats and in the community and really focused around issues affecting people with disabilities predominantly, but also and more recently around seniors in our province.
And I've worked for the Public Guardian Trustee's office now for pushing 20 years. I started out in child and youth services where primarily we were dealing with children in foster care and personal injury settlement reviews. Then I moved to services to adults where I primarily deal with committeeships, responding to petitions for committeeship, and various issues that arise from our authority acting as committee on behalf of adults with a legal disability. I'm spoken quite regularly at continuing education programs. I've seen Ken many times, and we've, of course, encountered each other often in that context. So I'm here to give a little bit more of the inside scoop on the Public Guardian Trustee and what you can expect from committeeship.
Thank you, Sarah. So a little bit of an outline about tonight's discussion. So the focus is really going to be around the various personal planning tools that are available for both alternate and supportive decision making. And I think it's really important to understand the distinction where we are looking at alternate and supportive decision making, and that ultimately what we're looking at is vehicles that enable folks that have capacity related issues to make decisions, and that really alternate decision making is really a last resort option, and we're always focused on the individual's ability to make decisions. And so in British Columbia, we have several vehicles that enable us to delegate and to enable, I guess is the word, supportive and or substitute decision making. And so there are three major vehicles that we're going to spend most of the evening on tonight. And I just want to reemphasize that these are all about living. And it's not about dying. This is all about living. These are vehicles that enable folks to still function in the community while they're alive. And I only say that because sometimes folks get a little bit confused about the distinction between a will and a power of attorney and a representation agreement and committeeship. And so we're going to run through the various tools that are currently available in British Columbia, and there are others here. We're going to touch on powers of attorneys, representation agreements, and then committeeship. And so I'll focus predominantly around numbers 2 and 3, which is powers of attorneys and representation agreements. And then Sarah is going to take us into committeeship. So in British Columbia, there is this presumption that when a person reaches the age of 19, they are deemed capable of making their own decisions. Now, of course, we all know that that's not necessarily true due to disability, aging, disease, or accident. And some people never acquire the ability to make their own decisions, and others, of course, have the ability to lose it. And that primary tools available to plan for incapacity, end of life, and support needs is fundamental to enable individuals to continue to be productive members of society, to engage in community, to have lives and fulfill their goals, whatever that might be, whether it's volunteering or whether it's getting to the doctor, shopping, making decisions such as routine banking. There's that need to enable folks, even if there may be issues of capacity. So the I guess the most common vehicle that is available is the power of attorney. And again, the power of attorney is a living document. It permits what we call the donor, this is the individual, granting the authority to someone, typically an adult, of course, that you trust to make both legal and financial decisions on your behalf, even if you lose subsequent mental capacity. So again, the powers of attorneys are limited to legal and financial decision making. They do not cover healthcare related decision making. Now the test to be able to develop a power of attorney is very high. And so these, traditionally these documents would not be available for individuals where there may be an element of diminished capacity. And so this is where we have family members perhaps with disability that may not be able to do a power of attorney. So this may be a more common vehicle for individuals that have full capacity and that are looking to have precautionary measures embedded in their plans to ensure that if they are to lose capacity or if they are needing assistance in terms of decision making affecting their legal and financial affairs, that they are able to appoint someone, and we call that person an attorney, and that person then has the ability to assist in making decisions for that individual. Now, there are three types of powers of attorneys. There's the general, the specific, and the enduring. So we'll run through each of those. So the first, again, is the general power of attorney. And this is a power of attorney that has broad powers to handle financial and legal affairs. And it ends if the donor of the power becomes mentally incapable. There are also specific powers of attorneys that have specific timelines and conditions, and these limit the powers of that attorney to specific tasks, property time, etc. And it's common, in these types of vehicles that it might just be for the purpose, say, of transferring property, and that would be the extent of that transaction. All right, so we have these three types of powers of attorneys, and then we have the enduring power of attorney, which is probably the most common power of attorney that most of us are familiar with. And again, there's broad powers, but most importantly, these power of attorney documents do not end if the donor becomes incapable due to illness, disease, or accident. So they are effective while you have capacity, but they also have effectiveness during a period where you endure or lose that capacity. So moving on to representation agreements, which Angela has commented on, is an area of great interest, and really, the history of this legislation. Again, a Made in BC piece of legislation is quite extensive and has involved community. There's been a real strong emphasis on community and the legal profession and the public guardian and trustee and government to develop representation agreements. So what are representation agreements? These are tools that enable you to appoint individuals around health and personal decisions. And that's really the intention, the primary intention. But within those representation agreements, there are distinctions, and we'll touch on that shortly. But what the representation agreement does do is it addresses a fundamental limitation of powers of attorneys, which only allows an attorney to make financial and legal decisions. So there are again two types of representation agreements. We have our standard representation agreement, which is commonly referred to as our Section 7 agreement. And then we have our enhanced representation agreement, again, are more commonly referred to, at least in the legal profession, perhaps, as the Section 9 agreement. These agreements are very unique and can be tailored to specify when and under what circumstances the agreement will be triggered and come into effect, such as a determination of capability. So the Section 7 agreement, which I would suggest to you is the most common agreement utilized in the disability community, allows an individual, and typically that's an individual with a disability, to help make routine medical decisions, personal care, financial, and legal decisions. And so there's a bit of a combination of some of the elements of the power of attorney, which really has a focus around financial and legal, and the representation agreement, which allows for the delegation and to the supported decision making of health care. And so the Section 7 agreement, has these very routine elements that are able to be supported, including payment of bills. This is not an exhaustive list. The legislation outlines this, the receipt and deposit of pension and other income, purchases of food, accommodation, and other services necessary for personal care, and the making of investments. But they're very limited. They don't go to the point of transactions that, let's say, permit the selling and refinancing of property. There's a limit on these routine financial affairs that are embedded into these agreements to enable individuals that may be of a diminished capacity. And that's really the big test. So, where you have your power of attorney, which has that high standard of capacity, the Section 7 agreement is really intended for individuals that may not have full mental capacity, and it's commonly where there is that diminished capacity. Another key point of these agreements is that there is no need for a lawyer to be involved in the preparation. So there's not a requirement for a lawyer, which is a great thing because immediately there's an element of avoiding a potential cost. But I think more importantly is that, and really, I think the crux of what we're going to try to emphasize tonight is that it serves as an alternate to committeeship. And some of the challenges with committeeship that we're going to talk about a little bit later. It's a vehicle that enables individuals that are perhaps not of the ability to develop a full-blown representation agreement or a power of attorney, but still be able to engage family or friends in supportive decision making, to enable those individuals to continue to have supports of family members when they turn of age in our province. And I think that's something that a lot of families are challenged with is, your minor children turn 18 in our province, and for those first 18, 19 years, you are there to support them, to enable them to be their guardians. And suddenly, at the age of 19 now, the world changes, and you can't do, or it's perceived, you can't do what you used to do because now they're adults. And so we want to be able to continue that ability to enable these individuals to still be able to be functioning independent in our community. But we don't want to take away their ability to be involved in decision making. And so the Section 7 agreement serves as a useful vehicle and as a really positive enabler of independence, I think, in our province. So the other representation agreement, or commonly referred to as the enhanced representation agreement, or the Section 9 agreement, again, allows someone to, you trust, to make almost, I'll say that cautiously, almost all healthcare and personal care decisions. So the Section 9 agreement is completely devoted to the area of healthcare and personal care decision making. So unlike the Section 7 representation agreement, it does not incorporate financial and legal decision making that is considered routine. So many of the standard provisions, of course, all of the standard provisions are included in the Section 9 agreement, but there are some other significant additions. So there's the ability to give or refuse consent for health care. There's the ability to delegate and have representatives that are able to make decisions about that individual adult, and to the extent of even advanced care and end-of-life instructions. So the Section 9 agreement also has a much higher test of capacity. And so the standards, the requirements for a Section 9 agreement, unlike the Section 7, require a full ability to understand and comprehend what is involved in delegating to a representative the decision making and supportive decision making around healthcare. So a Section 9 agreement would have a very similar test of capacity that a power of attorney, or even a will for that matter, would have. And so, again, these Section 9 agreements may not work for family members where there may be diminished capacity or where capability may be in question. They are really intended for individuals that have that ability to make decisions and to have the requisite capacity. So there are some specific execution requirements for a representation agreement, whether it is a standard or an enhanced agreement. And the legislation outlines those requirements. The adult, the representative, and a monitor, if there is one that's required. And a monitor is really there to oversee and step in where a representative may not be performing their duties. The monitor can act as almost as a bit of a cop, I guess, is the word, over the actions and the responsibilities of that representative. The adult individual that is executing a representation agreement must sign in the presence of two witnesses, unless one of those witnesses is a lawyer or a member of the notary profession. So there are a number of other planning options available in our province, and I'm only going to really briefly touch on these that folks in our province might want to be aware of, and that is the issue of organ or body donation. And this is, donations potentially for research or for educational purposes. A consent would be required for body donation while you are capable of understanding your wishes. And you must register those wishes, and we encourage you to register those wishes with the organ donor registry. Another, I guess, relatively new vehicle in our province is advanced care directives. And these came out in September of 2011. And these are healthcare-related documents that set out a further method to give or refuse consent for healthcare that you might be offered through a written and clear set of instructions, while again you have full mental capacity. And these are typically applied in situations where you do not want a certain medical treatment, for example. And so, for example, you may say, I do not want to be resuscitated under any conditions, or commonly a DNR order. And so that can be articulated in that advanced care directive. I do not want medications. I do not want blood transfusions. Very specific. They have their limits, of course, because they are very limited in terms of their usage, whereas the representation agreement is much broader, has that ability to engage supportive decision makers, your representatives, in actually making decisions. And then I guess the most recent sort of vehicle in terms of planning is a relatively new phenomena, not only in British Columbia, but Canada generally, and that is the concept of medical assistance in dying, which is continuing to undergo major transition as we speak. But effectively, what this now permits is that someone that is 18 years of age or older who wishes to die with dignity, has the ability to request medical assistance. There are a large number of criteria, too many for us to run through tonight, but it's another vehicle in terms of decision making that I think is relevant, and there are some real limits on that legislation right now, and I think there's a real push in the country by many to try to expand those rights to a number of different groups, including people with disabilities, of course, and various types of disabilities. And so you may want to stay tuned for further discussion, probably further Supreme Court case law that might be evolving in the next years. So we're going to move over to committeeship.
Great. Okay, so I'm taking the piece involving what happens when there is no planning, or when there was planning, but the planning fell through. And there's a variety of circumstances where this can happen. There are a great many people who just really don't like to think about the potential or possibility of their incapacity. So despite all of the array of options that Ken has gone through, they have not availed themselves of any of them, and then they've reached the point where they're no longer able to manage themselves and no longer able to take any further steps. There's also the circumstance of a person who has had developmental disabilities for their whole life, and it's not the variety of outcomes are not available. They do not have capacity to do a representation agreement, so the nature of their incapacity is such that they can't avail themselves of the options. And then there's circumstances where the best laid plans go wrong, and that is unfortunately an area that we deal with quite a lot in our office. Okay. Where there was a power of attorney appointed, but things went awry, either the power of attorney is no longer available, or there's been some problems with how they've been financially managing. So that's an example of the circumstances where a court appointed guardian is necessary. We still use the language of committeeship in BC. We are the only jurisdiction, I think, in Canada that does so. Everyone has moved on from that to a property guardian or personal guardian. But what committee of estate and committee of person mean is a property guardian and a personal guardian. So why? Why are we using that kind of language? Well, because our governing legislation is the Patients' Property Act. And this is a model of guardianship that has not changed since mid-last century. And it's based upon a model, as you can tell from the title of the legislation, of institutionalization, of a profile of someone who's incapable, who would be probably have developmental disabilities that have them institutionalized, or they're in a psychiatric unit, and someone has stepped in. That is not the profile of most people who would need a committee today. They are not patients, and oftentimes, certainly our observation in our office is the rise of dementia and Alzheimer's and dementia-related illnesses dictates that many people who get involved in the committeeship process are people who are quite elderly. And they live at home or they live in the community, and it has become necessary because of the nature of their assets that someone take over their financial affairs. So does it matter? Does it matter that we're using this really old legislation to deal with adult guardianship? I think there's a strong argument to say that yes, it does matter that we're using very old legislation here. And just to take it wider or talk in sort of more global or wider terms, in 2006, the UN General Assembly formally adopted the Convention of the Rights of Persons with Disabilities. And the purpose of this convention was to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. That's a principle I think that everyone can get behind. Article 12 of the convention, however, creates some specific types of issues, particularly in Canada. Canada is a signatory of this convention. And the article, in sort of broad terms, says that persons with disability enjoy equal legal capacity on an equal basis with others in all aspects of life. So there's a presumption of supported decision-making. Parties shall take appropriate measures to provide access by persons with disabilities to the support that they may require in exercising their legal rights. When you look at the Patients' Property Act, that's not what it is in that legislation. Certainly there have been some amendments to bring it more in line with the supported decision-making model, but committeeship really is someone coming in and standing in the shoes of the adult with the power to make every decision on their behalf. It's an agency type of relationship. There's no real guidance in the Patients' Property Act as to how you would make those decisions. And so I think there's a continuum and certainly a tension between the supportive decision-making model and the substitute decision-making model that's hard to reconcile. And Canada hasn't reconciled it. Canada provided its interpretive declarations with reservations about this article, specifically in relation to using substitute decision-making models. And Canada promotes the substitute decision, not promotes, but uses a substitute decision-making model. And then the other avenue for someone having a property guardian would be by the public guardian trustee becoming committee of estate by certificate of incapability issued under the Adult Guardianship Act. I'm not going to talk too much about this. This is more of an administrative process by which the public guardian trustee becomes committee because it's a last resort option and there's no one else available to bring an application to court. This has had an overhaul recently, thank goodness, so that there are very clear parameters around what has to happen in this context in terms of notification to the adult that this is underway, notification to family members, an opportunity to object to the assessment or seek reassessment, and a court option if the adult doesn't agree with the reassessment. So I won't spend too much time on that, but that is an area that has had recent changes. Anybody can become a committee. So this, again, this is not a chosen person by the adult. This is not someone that the adult has expressed that they trust necessarily. You can do a nomination of committee in the Act. So as part of your global planning, you can say, well, if I do need a committee, this is who I would nominate to do that, and then we get notice of that, that notification. So you can take steps to decide in advance who would be your committee, but often it is someone that the adult has not chosen. And in those circumstances where there is no one else available, then it may be the public guardian trustee, in fact, who may apply or be appointed, which might be an outcome that the individual never expected or anticipated. Because of that, it is considered a last resort measure when all other options have proven to be ineffective or unavailable. And there is a process involved in this. So to go to court, you require 2 medical affidavits that swear an affidavit in support of their opinion that the patient is incapable. There's some rigor required in the medical affidavits. The diagnosis is required, and also clinical findings as to what the nature is of the disability. If you're looking for someone, or if someone is looking to become commitee person, you want to see in the medical affidavit that the adult cannot prepare food for themselves, or would not know what to do in an emergency, or may become lost. And you want to see specific evidence as to why a commitee person would be of assistance to them. Also important that there's some sort of prognosis, so that in certain circumstances, it may not be necessary. The person may be unconscious for a period of time, but not necessarily over the longer term, or situations involving a person who may have suffered stroke. So they start out quite incapacitated during the early course of their recovery, but they may regain their capacity later on. So usually the medical affidavit will refer in some way to the situation as it is now, and the situation as it's likely to progress. And then the affidavit of kindred and fortune, and again, this is the kind of language that's used in an older statute. What that actually means is who are the family and what are the adult's assets. And so you set out a lot of detailed personal information about the adult and about yourself as the petitioner. You provide the patient's age, their current living arrangements, their anticipated plan for care, and their income, assets, expenses, and liabilities. It's not a requirement of the affidavit that you set out your plan of management of the adult's affairs, but I always recommend that people do so, because it addresses potential problems down the road on the passing of accounts. For instance, it may be that the immediate plan is to sell the property because the adult is going into facility, or it may be the plan that the proposed committee wants the adult to live with them, and then they will provide care, and they would want some sort of reimbursement or caregiving allowance in order to do that. And it's always useful to disclose that up front, that you are going to reimburse yourself for caregiving services, or that your actual plan is to immediately liquidate the real property assets. What I find problematic with the Act is that it doesn't really give a lot of guidance to a committee. So because it's quite old, it's only a 30-section statute, which is almost unheard of in legislative drafting currently, but all the guidance that it's available is in the middle of the legislation, which in very broad terms just says a committee has all the rights, privileges, and powers of the person would have had if he or she had capacity. So in other words, you stand in their place for the purposes of all their decisions. Section 18 provides that powers must be for the benefit of the person and his or her family, having regard to the nature and value of the person's property and their circumstances and needs, and here's the key element of that, and the needs of those of his or her family. So you're looking not just at the adult, but you're also looking at what the family needs. Why is that section there? Well, because if a person has dependents, the committee would want authority to provide for the dependents. There's perhaps circumstances where they gave out gifts to certain family members or paid for certain things for family members. But there's a lot of gray in this area. Where does it stop and start? If you're going to give gifts, how much of a gift can you give? Do you need court approval to get a gift? Can you make a will for the adult? Or can you do something that would affect their estate plan or do some sort of tax freeze? And so you really have to turn to the common law principles. In other words, look at the legal cases to determine what the parameters are of your authority under that section. And section 18.2, which is tucked in there, which is a nod to the supported decision-making model that was inserted when the Adult Guardianship Act was amended to create a certificate of incapability process. So this is the area where you will see, luckily, in the Patient's Property Act, the supported decision-making notion that a committee must, to the extent reasonable, foster the independence of the patient and encourage the patient's involvement in any decision-making. Certainly when we are acting as committee, that has been a part of our policy as committee for a long time, is to, if we were going to sell the adult's house, talk to the adult about how they feel about that, or talk to them about a particular approach that we would take in managing their affairs. Notification to the public guardian and trustee is required for these applications, and we get notification because we're looking for certain things, and also because we will have ongoing involvement in the committeeship. So we will look for security for the management of the adult's affairs. When someone has chosen someone themselves, it denotes that they trust that person to take care of them. But if it's a court application and it's maybe a family member or friend or trust company, then they haven't been placed in that position of trust vis-a-vis managing the adult's affairs. So it leaves the question of, well, should they then, for instance, post a bond for their management so that if something goes awry or something unforeseen occurs, there's some remedy, and the bonding, which acts as an insurance policy, will pay out on the claim. That's one form of security, is bonding. Another form of security, and this is also embedded in the Patient's Property Act, is to put a restriction on the committee's management of the adult's affairs such that they would not be able to, for instance, sell property without the written consent of the public guardian trustee or further order of the court, or that they would not be able to access capital of a particular investment without the written consent of the public guardian and trustee. So the public guardian trustee has this ongoing role to provide consent and then also to pass accounts. And that's another requirement of the Patient's Property Act, is that you have to provide your accounts on a timeline as set by the public guardian trustee, who will review the accounts, set remuneration for the committee, and then give you a certificate of passing, which means that you've managed appropriately. So there's a series of administrative steps that can happen in the course of a committeeship. Because the Patient's Property Act is so lean in terms of giving a committee guidance as to what our expectations would be, or what their obligations are, what their duties are, we've created the Public Guardian Trustee Handbook. And so the handbook ends up being a 40-page document, actually, that talks about who are you in relation to the adult? Well, you're a fiduciary, which means you have an obligation to place their needs first. Can you estate plan? Well, no, you cannot. Can you do a will? Enter into a contract of marriage? All of those things are things you can't do, and we outline the do's and don'ts, in addition to providing something of a to-do list. So for an adult who becomes incapable, but perhaps they ran a business, or they were an entrepreneur, they have a lot of real property, they have business interests, it can be very complex. And so the to-do list sort of walks through all of the things to consider. When the committee is brought on behalf, perhaps by a parent, on behalf of a child who is under legal disability, the to-do list is quite a bit shorter. The asset mix is not quite as complex, but it still does provide some guidance about what our expectations are and what their role is. And this is all available on the trustee website, which I've provided on the slide. And also on the slide is the account submission package, which sets out, if you have to pass accounts, then what do the accounts have to look like? What kind of information needs to be on there? What are the expectations? Well, the package is on the website. I think it's fairly straightforward. I think it guides a committee very simply through what kind of assets need to be declared, income tax returns need to be provided, but certainly our office is available to answer any of those types of questions. Once the court's involved and a committee is appointed, the effect on the planning documents is they are terminated. So that's an important consideration as well. So in very contentious situations, it is kind of useful to have the court order, because that means maybe there was competing powers of attorneys floating around, maybe there's a lot of contention. The person who has the order can slap it down and say, I am committee. That means everything else is void. So what are the pros of committeeship? I come from the perspective of the public guardian trustee, so I see the situations, unfortunately, more often where the adult is really vulnerable and has been taken advantage of. And so the advantage, I would say, of committeeship is you have that court order. And so it's full protection to the adult. It means you can go to the bank with the order, and the bank, everyone understands what a court order is, what it looks like, and they know the bank will know they don't deal with the adult anymore, they deal with the committee. So I think it's very useful where there are real concerns for the safety and financial security of the adult, that they really do need some sort of protection. And of course, it is that last resort measure. If there's nothing else that can be done, or if there's no other tools available, then it is a mechanism for providing oversight and protection for an adult. And then there's the oversight of our office, so we do review accounts. We will be available to assist a committee in situations where there's confusion about what their role is or what the next steps are. And so it provides that additional protection of providing the accounting to the public guardian trustee. But there are downsides as well. And I alluded to them in the earlier part of the presentation, which is that it takes away the adult's autonomy, and it removes them from any ability potentially to involve themselves in how their life is being managed. And that's a very difficult thing for a lot of people to face. And it's a difficult concept on that continuum of how we view providing care and services to people with disabilities. It is in the more interventionist model. And it's also expensive. So I talked about the 2 medical affidavits. There is an expectation of the courts that they be detailed, that they provide clinical findings, that they are recent, and doctors get paid to provide the affidavit. That is a very high disbursement. It can cost hundreds of dollars to get those medical affidavits, and then the court application itself can be thousands of dollars. So a rough estimate of defer to Ken on what the cost would be, but I'd say probably $5,000.
$5,000 to $10,000.
Yes, and to that point, if you are in a more remote area, it can actually be quite tough to get the 2 medical affidavits. You're waiting for the specialist to be available, and specialists are notoriously busy. So it does involve a considerable amount of delay in taking action on behalf of the adult. It's also not a particularly private process, so the affidavit of kindred and fortune discloses, I know adults who don't like people to know their age, but certainly they wouldn't want people to know all their investments and where their real property is, and everyone in their family, especially if they have a family where there's some contention, when committeeships get contested, I don't know how many of those you've dealt with, Ken, but it can get first of all, very expensive, because then there's a lot more affidavit material that needs to be provided, and a lot more responsive material, depending on what allegations are made. And then it's also a lack of privacy for the whole family, and people's relationships are then exposed to a forum that's really quite public. The other difficulty with it is that it is not easily reversed. A declaration of incapacity will mean that you will always require a committee. And the only way out of it is to go back to court and say, well, I'm capable now on 2 medical affidavits, so therefore I don't need a committee anymore. But for a lot of people, that may not be the reason why they don't want committeeship. They may no longer have any assets that need to be managed. The situation might be quite stable, but you are left with this declaration. You are incapable and require a committee unless you're not capable anymore. And worse is, well, better and worse. Once someone requires a committee, there always will be one. If there's no family member to do it, it defaults to the public guardian and trustee. But you can imagine the situation of the person who's always been very private, who's always perhaps not wanted government involved in their life at all, and wind up in a situation where not only is their life quite exposed, but then they end up with the public guardian trustee actually taking over. So I think that's something not to be taken lightly, is that it's useful to look down the road when your child is 21 and 22 and you're thinking, well, I think I need a committeeship order because then I can make healthcare decisions and other decisions for my child. It's useful to look down the road and think, okay, well, what do you want to happen if you can no longer do that? Or what do you see, how do you see the situation unfolding? And semi-facetiously, I put in the con is the oversight of the public guardian trustee, because it is an administrative element to committeeship that is quite rigorous. Now, certainly when you're power of attorney, the Power of Attorney Act specifies you have an obligation to keep and maintain records, and someone can call for those records. The donor of the power of attorney can call for the records. But you regularly need to deal with a public guardian trustee. Depending on the nature of the order obtained, you'll have to come to our office, pass the accounts. on a regular basis. What we have done in circumstances for adults who don't have assets, so perhaps the adult is on PWD benefits and doesn't have any other assets, and the situation is very stable with their family, we would have one passing of accounts, and then the committee would go on what's called discretionary reporting. So the passing of accounts isn't set in the legislation as a particular timeline. The public guardian trustee sets the timeline for the passing of accounts, and in cases involving disabled adults, we would say no more reporting required. Okay, I'll refer to the submission perhaps. Passing of accounts, and this happens before the court in other contexts like state administration, it means your accounting for your management of the adult's assets. So if you've sold property, we would want to see the contract for purchase of sale. And so what does it mean when we pass your accounts? It means you provided all the information that we've asked for, and we have said, yes, you've done a good job on this, and you're entitled to remuneration that we have authority to set under the Act. So it is a process by which you will set out the details of the adult's circumstances, what is in their bank accounts, what term deposits they have, all of their liabilities, mortgages payable, and other loans, charitable donations, and then list, you provide account numbers, and then you list the amounts and in more detail on a separate detail sheet. I think it's set up in a way to be fairly straightforward. So once you provide that submission package and we've reviewed it, we will issue what's called a certificate of passing. And so it just means that for this period of time, we're satisfied that the committeeship has been managed appropriately. And then if the committee wants remuneration, meaning they want to get paid for acting as committee, we will fix the amount of the remuneration. So because it is a very heavy measure in terms of protecting an adult or managing their affairs, it's very, I think, important to look at issues like, is this committeeship truly necessary? There are many, many adults on disability who are not able to manage their affairs, but they don't have a committee, and they don't necessarily need a committee. When the Adult Guardianship Act was changed, and this is the certificate of incapability process by which the public guardian trustee becomes committee of the state, when it changed, it set out a test for when a certificate of incapability should be issued for an adult. And the test, it's a 5-point test that the adult needs to make decisions about their financial affairs. They're incapable of making those decisions. They would benefit from the assistance and protection of a statutory property guardian. And the needs of the adult would not be sufficiently met by alternative means of assistance. And the adult has not granted power over all of the adult's affairs to an attorney, or they have, but the attorney is not complying with his or her duties. So the key element of that is that the needs of the adult would not be sufficiently met by alternative means of assistance. And certainly we are in discussions often with the health authority who issues the certificate of incapability about what alternatives have we explored, what have we done to use a less intrusive measure than the public guardian trustee getting involved. And those can be things like if the adult's on disability and they have a joint account with a family member, if that could perhaps continue, they may not have, they may be able to orchestrate or organize income tax filing informally. There's other mechanisms, perhaps, than a certificate process. Now, under the Patients Property Act, there really is no test of whether or not you require a committee. It's just straightforward. If the adult's incapable and the court satisfied the adult's incapable, they can make the order. So it's not really addressed in detail in the Patients Property Act, and it wasn't intended to be addressed in the Patients Property Act. So I flagged this for the audience as part of the way forward is going to, potentially is, that the test very similar to the one in the Adult Guardianship Act will start to apply to committees. Certainly there's legislation in the books not proclaimed that would contemplate a more rigorous scrutiny of a petition for committeeship where the court would go through the same considerations that the health authority would prior to issuing or declaring the adult incapable. So when we're reviewing these, certainly in the context of referrals to our office to act, it is not something that's required for an adult to receive disability benefits. Federal pensions can be managed by a pension trustee often, so there's often an alternative there to have a family member act as pension trustee. We certainly talk about representation agreements often with our referral sources. And CLBC funding, whether or not it assists. It is an open question. I hear a variety of things about that. One thing I did hear was that if there is a committee, that committee will not receive CLBC funding. Now, I don't speak for CLBC, so I don't know what the policy is, but I think it's useful in considering whether to pursue committeeship, what the impact is with the dynamic with the CLBC. So from our perspective, numbers that I find interesting are that we have about 400 committees on what's called discretionary reporting, and I described it earlier, and that would suggest that there are no assets to manage, and it's likely that PWD is the only source of income, and I find that a very high number of committeeships, and in fact, it does represent about 20% of committees. When I do review these applications, I sometimes go back to council and say, well, what is the reason why this application is being brought? Is there a specific purpose for it? And I get a variety of answers around that. But when you look at what we do in referrals to our office to become involved, we only become committee of a state by certificate in about 30% of our referrals. So we're always casting around for a way not to put someone through a certificate.
What I had emphasized to Sarah was that these numbers were startling to me as well. Quite large, but you know, from my dialogue again with Angela and other practitioners, yourself, and other members of the estate community, and families generally in the disability community, this concern that you've now reached the age of 19, and what has traditionally worked for that family in terms of mom or dad being there to support that individual with a disability now changes because they're 19. And families, I think, have been led to believe that committeeship may be, you know, one of the only options. And I think it's reflective in, you know, these statistics as well, because I think it's important to reflect on the alternatives that are available. And I think it's such a positive that we have the PGT there to sort of say, wait, let's assess this further. Let's determine if it's absolutely necessary. Are there any other vehicles that might work? And you've outlined several of them already tonight that may still enable, I think that's the important thing here, is enabling that independence while still managing to move forward, even though we've entered this sort of new world of turning 19. And wanting to ensure that mom or dad or a family member, a brother or sister, can still support that individual in other ways. So I think there definitely has been a sense, I think, in the disability community and in the profession, that committeeship is being pushed strongly as an option. And I know these statistics, again, really resonate, I think, on what we're actually seeing in the community, and I think it's one of the major reasons why we wanted to conduct this session, was to hopefully educate families and enable them to have some knowledge that yes, committeeship is an option, and yes, there may be circumstances where, you know, it is important and viable, but there may be circumstances where there may not be viability for that option, and maybe there are more less intrusive options, less costly options that enable the protections and the supports without risking or jeopardizing that individual's ability. And I think, you know, when I speak of this, I really speak of it on, you know, the statistics that you pointed out. An individual with a developmental related disability turning 19, insignificant assets. We're not really focusing on the elder adult who has substantial wealth, perhaps, where, you know, committeeship may be a viable option at that point, where, you know, a power of attorney is not effective or a representation agreement is not in place. So, thank you.
And that's the pro of the committeeship that I flagged earlier, is that it's useful when there is very great risk to the adult and they are very vulnerable. But In family situations, the family is very supportive, and it's not the case that, yes, you've been your guardian for your child when they were under legal disability due to their minority, but that doesn't make you any less of an advocate when your child's an adult and you know the service providers and you know what your child needs, and you hopefully should be able to manage providing for them. This isn't a situation of risk. It's just a situation of someone feeling like they can help the adult and make decisions for them. And going back to the early part of the presentation, it is concerning if there is a push for people to say, get committeeship, because that's not really the road that we are walking down in future directions. When I do review these applications and it is someone on disability and it's the parents applying, I do ask a few questions, but at that point, it really is at the petition stage when the petition's been filed, it's really almost too late.
Yeah.
And they're not really prepared to entertain ideas from the bureaucrat who says, yes, you've spent all this money, but I don't think it's necessary. And I certainly would be very reluctant to argue in court against a family who really had did this under the best of intentions and really were given the advice that this was the right thing to do. I would never stand in the way of that. But this is why outreach is so important, because I think it is critical that people understand that the less intrusive option is really the way to go if that's at all possible. And you're looking at a situation of really no risk to the adult. It's just a question of things changing between their minority and becoming an adult at 19.
Absolutely, yes.
I think we've probably hit this.
We have, yeah.
What the advantages of our Section 7 representation agreement. Certainly, Section 7 representation agreements in the literature that I've read are viewed quite favorably across Canada, and I think even in the international community, as this is a beautiful supported assistance model. The Representation Agreement Act talks about consulting with the adult, following their wishes if they're able to state them, or if they can't state them, their previous wishes if known, and the best interest of the adult being the last part of the test. So I think it's a very good way forward. It's a great instrument for that. It's certainly a very low-cost instrument, and it keeps you out of a court proceeding that lacks privacy and that can get quite expensive. Did you want to weigh in on it?
I think it's just important here for families to just reflect on what a Section 7 agreement does and what it doesn't do, and in this context, because although it does enable great things and it empowers and it provides the ability to have that supportive decision making, it has its limits as well, and it's not intended to be broad-reaching, far-reaching, where there are substantial assets or where there are major healthcare decisions that need to be made. I mean, I think that's the important thing, is for families to focus on the Section 7 agreement being intended for really those routine financial, legal, and healthcare related decisions, and that test for capacity is a much lower test than those other vehicles, such as a power of attorney or a representation agreement, which are in fact the de facto vehicles that hopefully exclude the need for committeeship. So I think it's important for families to understand the relationship of all of these vehicles, to understand what they mean, and if they don't have that clear knowledge, to get that knowledge before they embark on whatever course of action. So when your sons or daughters are turning 19, it's important to do your diligence and to go to the Public Guardian and Trustee website, understand what is committeeship, review these materials, go to the NIDIS registry, which provides amazing and excellent support around representation agreements. Come to Angela and FSI, their team, who also do a lot of work in this area, an amazing resource that is available for families. So use that knowledge as a foundation, so that when you're contemplating planning for that loved one with a disability or a diminished element of capacity, that you're considering the various vehicles and recognize the advantages and the disadvantages all of these vehicles, but also understand that committeeship is intended to be really that last resort option. And when we embark on that, it is a last resort. And with that comes some stringent requirements, a stringent test, and ultimately a cost that I think we want to justify as well. And as a practitioner, when I'm asked to develop a committeeship application, there's a certain onus on lawyers as well as officers of the court to provide knowledge as well to a prospective client that might be considering one of these vehicles to enable them to have a foundation of knowledge before they make really big decisions moving forward. So that ends our presentation. Thank you, everyone. We're quite happy, Angela, to take questions from the audience. And I know that you've got several already lined up.
Yes.
So we'll let you go ahead.
Okay. So first of all, I just want to make sure that everybody can hear me, and I'm pretty sure they can. So the first question came in. Great. So the first question that came in said, sometimes the public guardian and trustee directs in a trust deed to have a committee upon turning 19 if the beneficiary has diminished capacity. Why is that?
What happens with the disability trust? I think the classic context for that would be a large personal injury settlement that happens when the child is still under the age of 19. And the funds are managed in the trust by the parents and a corporate trustee to provide all the services and all the care that is needed while the child is a minor. But there is this presumption of capacity when the adult turns 19. And we've struggled with this very idea within the office is, okay, you don't want the trust to continue indefinitely because that person should have the option to manage their own affairs at age 19 in accordance with the principles as enunciated in the Adult Guardianship Act that they're capable. But oftentimes they won't be. The nature of their disability is such that they won't be capable. Well, how do you decide that they're not capable? What's the mechanism? And there isn't really a mechanism to go into court and say, court, just make a declaration in the absence of it being a committee type of declaration under the Patient's Property Act. But it does create some issues around that. So the requirement is really about the person turning 19 and it being established that it's appropriate for the trust to continue on past their age of 19. And the committeeship was the only mechanism we could identify to actually make that determination by a court.
Yeah, and it's a common question, and Sarah and I we've dealt with this topic on a number of occasions now, and it's a challenge. I know there's frustration in the community, but I think it's that presumption that we can't deem a minor to be incapable when they're a minor. We need to give them that opportunity to take on responsibility, and I think that mechanism is there as a method to enable that individual when they become of age. Because again, as we talked about earlier in the presentation, there's a presumption of capability at the age of 19, and so that's I think the common vehicle there is to give options to that person who was a minor, perhaps at the time of that personal injury settlement, and now they're at the age of 19. Let's give them another opportunity to demonstrate that perhaps there is some ability to make decisions.
Okay, so the next question is, does a Section 7 versus a committeeship, or I guess the question is, does a Section 7 or a committeeship impact the disability tax credit eligibility?
That is a really good question. and it's something that's come up. The disability tax credit is a federal credit, of course, that has a very significant test that the federal government applies, and as many families with disabled members know, the test federally can be quite distinct from the test for provincial disability benefits. And I think the relevance of that disability tax credit is that, and I think we're referring to the qualified disability trust criteria that's recently come out in the last 2 years, which now states that a discretionary testamentary trust, and I'm sorry if I'm using language that folks don't understand, that was the previous 2 webinars, so go back to those.
You can go back and look at
understand
those
that
versions.
and so the new qualified disability tax rules suggest that an individual must qualify for the disability tax credit to enable that person, that beneficiary with a disability, to take the benefits of marginal rates of tax. That's the key element here. But there is a requirement that both the trustee of the trust as well as the disabled beneficiary receiving the disability tax credit must be able to elect which trust on an annual basis will receive the benefit of that marginal rate. And so the question that has come up is that what if that person with a disability does not have capacity, or they have a diminished capacity and they cannot elect? Then how are they to elect for the disability tax credit and therefore the lower marginal rate? And so, and I've sought guidance from Revenue Canada on this, and I've not heard, but there is a theory that a Section 7 representation agreement vis-a-vis a representative could enable a representative to assist in electing that trust through the disability tax credit on an annual basis. Have you had that on the committeeship? Your thoughts on that? I mean, I would presume as well that as a committee of a state, you would have that ability to elect. And I would think so. Again, the committeeship would definitely, I think, permit it. I would urge families and those out there to seek good tax advice. This is not necessarily just a legal question. But I think the question that many families might have is, would a Section 7 agreement potentially enable that election? And I think the answer could be yes. I think an argument could be made that yes, under those routine financial administration, that an election could fall within that category.
But the routine is it's enumerated in the regulation.
And it's not, it doesn't list, and I think that's the challenge.
Yeah.
It doesn't list, and so, I think that's where there's some concerns, because the federal government has now initiated this qualified disability tax credit, and your person with a disability must be a participant. So does that now mean that the only way you can elect if you have a diminished capacity or a lack of capacity is now therefore through committeeship?
Okay, so the next question was actually sent in ahead of time for somebody. Their question is, my question is in regards to the limits of an enhanced representation agreement. You've articulated that a Section 9 agreement allows the individual to appoint someone they trust to make almost all health care and personal care decisions. What is the limit to the decisions that can be made on behalf of the person? For instance, the representative, the individual's father in this situation, chose to not include the individual's mother in planning meetings. Is that within or beyond the intent of a Section 9 agreement?
So the Section 9 agreement is really intended for, again, at the forefront about supportive decision making. And so the involvement of a representative is that that individual is chosen to engage in supporting decision making of the adult. And again, I think it's really important to recognize that there is, even with a Section 9 agreement, there is always a presumption that the adult is still capable of engaging. And so if there is that ability of the adult to engage, they still are there to make decisions. The representative is not there as a substitute decision maker. And I think that is an area where families sometimes misunderstand the relationship between, committeeship, which is substitute decision making, and a representation agreement, which is really about supportive care, supportive decision making. And so that representative is definitely chosen and has a de facto, beyond supportive decision-making role, but ultimately it's the adult that still is looked at by individuals in terms of third parties. So whether it's in a care environment, we should always be looking to the adult first. What is their wish? What are their last known wishes? Not letting the representative presume that now they're making all the decisions. So I think there's that context of understanding the relationship between the adult and the representative. But I also think that it's important that the representative, when they're engaging in that supportive decision-making role, reflect on the wishes of that adult while they were potentially of capacity and what their wishes were at that time. And that should be reflective in that supportive model. And so if that individual, that adult had a prior desire to engage family members in dialogue, one would hope that that representative would follow suit and engage the same sort of mechanics that the adult would have. But again, enabling independence, enabling engagement of the adult in that process.
I really appreciate how you talk about that, because I know in our organization language is so important around this, and I know that often we hear very well-intended families using language that is very diminishing around their sons and daughters. Sometimes you'll hear them say, I have a rep agreement for my son or daughter, or I took out a rep agreement on my son or daughter. and it's well-intended language, but yeah. It does. And I think that sometimes even just a shift in how we talk about what a rep agreement is and helping people to understand that actually your son or daughter has a representation agreement and you are there to support them in their decision making. The shift in language helps the shift in perspective and thinking.
And it is there in the act. So
right.
You can always go back to the act when you're making these decisions and remind yourself of what your duties are as a representative. Right. You have duties to the adult. So you have to be cognizant of that. Yeah. This is certainly a source of referral to our office, that a representative may not be complying with their duties.
Right.
Especially in a contentious family situation. And it's a very delicate, these situations can be very delicate, but I think the key is to go back to what your duties are. Not what your rights are as representative, but what your duties are on behalf of the
Yeah, of course.
The representation agreement also has certificates that are attached upon the execution, and we have the individual representatives sign a document that effectively outlines all their duties. So when they sign that representation agreement or they sign the declarations, they actually get a list of those requirements. And it's always important. I always encourage families to review those as well to understand what this means. And you're absolutely right. There's this misconception that somehow a Section 9 or even a Section 7, for that matter, a representation agreement, necessitates a lack of now autonomy or the ability to engage in decision making. And I've heard that as well, Angela. Yeah. Families have said to me, I thought we were creating a representation agreement that enabled me to take on this responsibility. But my son or daughter now says, I don't want to listen to that. I want to follow what my beliefs are. And so you've got to educate. And I think that's, the intention here is to provide some foundation of knowledge, hopefully for families, that will enable them to ensure that their children, their family members, continue to have a good life in our community.
Let me just see if there is another very long question here, and although respectfully someone else tried to answer it and very likely answered it correctly, I'm still going to respectfully ask the question just to make sure that we get the answer that she needs. So my family has been in the midst of a comity of the person application for over 2 years since the family member turned 19. The application as the family has received a settlement via an ICBC settlement. The challenge has been accessing medical doctor available and willing to complete the competency requirement. We were unaware until recently that there is also a committee of property which seems less rigorous. I'm not sure there's a question there.
So I think the important thing to recognize there is that I think Sarah did a really great job of outlining the different types of committees that are available, and so it sounds like there's 2 here. We're talking about the committee of estate or property, and then the committee of person, which really is about healthcare, and so those are 2 distinct requirements. And they require, and in the context of the physicians conducting an assessment under those affidavits that Sarah mentioned, a physician will, if instructed, will look to both issues of management of financial and legal affairs, again, the committee of state, and the management of the person, which is then healthcare. And so it may be that the application is one or the other, or it may be both. Mm-hmm. But it will depend on the individual. And there are common situations where committeeship of estate and financial matters is granted, but may not be necessary around healthcare. And there may be vice versa, although I see less and less of that. Your thoughts, Sarah?
Yeah, I think it's common to have a committee of estate without having a committee of person, because to have a committee of person, you have to be incapable of managing your personal and healthcare decisions. And personal decisions include things like being able to cook or being able to, the classic is get help in the case of emergency. Financial is a little bit different. It could be that your mortgage is in arrears, that the person's become flustered in terms of bill payment and managing their assets, that happens early. Certainly, I'm thinking in the context of dementia-related illnesses, that happens usually first, is that you can't pay bills or you're confused by your mail, but you're living at home and you're managing at home. You get yourself dressed in the morning, you go out and have a cup of coffee every day. And so in terms of your day-to-day and shopping, you can do that. It's just the issue around investments and bill payments and selling your real property where you become confused. So there are different tests of capacity.
Right.
And in the classic case of dementia, one usually fails first, and it's committee of estate, and that is more common. You do see a lot of committee of estate only, because a person can manage themselves. And then sometimes later on down the road, there'll be a separate application for committee of person because that person has now diminished further and they're unable to do their own personal care. So I don't know if that is responsive to the question, because there's a little bit of the disability trust embedded in that as well, and concerns about getting a second or getting a medical assessment for the purposes perhaps of a trust continuing. Anecdotally, I can say we've found that very hard in terms of sometimes tracking down a person who does not want to be assessed. And so you're in this particular case, we were managing the trust, and we weren't to continue. We were supposed to pay out the money to her on 19 unless she's incapable, which the only way to have that determination is through the court application. But she's out and about and in the community and has no interest in us. So it can be a bit tricky in terms of garnering the medical evidence that you need, which can be challenging in committeeships and in contested situations where perhaps the petitioner, the person who wants to get committeeship, doesn't have access to the adult anymore. Maybe they're living with another family member, or maybe they've just reached a point in their mental health where they're not answering the door anymore.
Right.
So, I mean, that's another complicated feature of making these kinds of applications. And not a lot of easy answers. Certainly in the certificate of incapability process, there is a mechanism for us to ask the health authority to issue a certificate on the basis of collateral information. So we haven't, the adult's not answering us and not responding to us, but we know from historical medical, we know from a social worker, we know from these reasons that they are incapable, and so you can put together that evidence. Our Patients Property Act, again, is an older piece of legislation, and there is very narrow grounds to get a medical opinion ordered. And I won't sort of go into the case law around that, but it's not a great tool in terms of securing cooperation of the adult in getting a medical assessment.
Yeah.